Well, hello, this is Niki Langridge, and I'm joined today by Rhys Taylor and Andrzej Bojarski. And the three of us today are going to be discussing what is no doubt on everybody's mind at this time, which is if you have a hearing coming up, should you be proceeding with the hearing or proceeding with negotiations and out-of-court settlement negotiations, or should you be, in fact, seeking an adjournment? In terms of my own practice at the moment, I'm finding that there's a real mixed bag of the two. So I thought I'd get together today with Andrzej and Rhys, and we would see what's been cropping up in our experiences collectively. What do you two think are the main considerations when one has to consider whether to proceed with a hearing or not?
Well, Niki, I think you can break it down into sort of two principal areas of consideration. First of all, there's the procedural considerations about what's going on in the courts at the minute. And secondly, there's substantive legal considerations as to whether or not it's appropriate for financial remedy cases to be heard, even if one can get over the practicalities. We're aware 2 weeks into the crisis that there are severe listing problems. Only yesterday, HMCTS published their business priorities, and they broke family law down into three areas: work that must be done, work that will be done, and work that we will do our best to do. And you won't be surprised to hear that financial remedies comes into the latter category. There are clearly more important things in the family court in terms of personal protection and the welfare of children that are going to be in the front of the queue, and financial remedies have to take their place. If it's possible for a financial remedies case to be listed, then of course there's the issue of it being heard remotely, and there's variable accounts as to how courts are coping with that. Some courts are being willing to accommodate telephone hearings or video conferences, others are yet to get up to speed, and it's a changeable story on an almost daily basis. Aside from the suitability, or the ability rather, of the court to accommodate the parties, you've then got the question as to whether or not the parties are up to taking part in a remote hearing. There'll be some parties who have particular vulnerabilities or disabilities which make it very hard for them to participate on a remote basis. So there's all of those considerations which one has to look at, and they're very real considerations that are coming up, and lots of FDRs and final hearings are being adjourned on that basis. But let's just say we've either got a court or the parties have been able to agree a private tribunal, maybe a private FDR or even an arbitration. One then moves to the substantive issues as to whether or not it's possible in the current climate to either settle or to have a case adjudicated. The housing market has frozen, the mortgage market is non-existent at the moment, and the stock market has plummeted, affecting many investments, and in particular pensions. So the reports that we had maybe just 3 or 4 weeks ago now are in some circumstances works of antiquity and would need to be updated. And even if they're being updated, who can predict on an earnings basis what the value of a company is going to be going forward? If one had a crystal ball, it would be very helpful indeed. Are we in for a short, sharp shock and we'll be out of this by June? Or does this mean we're in for a longer haul and something akin to a depression, which may affect assets for a very long time? So there's general uncertainty about the reports we have, or the reports we might want to get, uncertainty over assets generally. Also, parties losing their income, and there's no saying that earning capacity can be easily made up elsewhere. One reads in the reports of, for instance, an airline pilot who's taken another job as a Tesco delivery driver, and no one could really say that he's being unreasonable in the circumstances. In fact, that news report is one really celebrating what he's doing in terms of making himself useful generally to the economy. But one can sense that in other circumstances that might be regarded rather differently. So there's a lot of uncertainty out there, which may make it very difficult or even impossible, subject to your instructions, of course, to be able to resolve a case at the moment.
It's certainly a time of great uncertainty for very many people, and I think we all live, both personally and professionally, with that constant anxiety of what the future holds. But does the uncertainty mean that we just can't go ahead with anything at all? What do you think, Andrzej? Have you been able to proceed with any of your hearings recently?
Well, yeah, well, we have. I mean, it's still very early days, and I'm not sure that we can say there's a single answer that applies to every case. I think it comes down to an assessment of risk in each individual set of circumstances and for each individual set of parties to take. And because it's an assessment of risk, in a way, it's not really a decision the lawyers are going to have to make in most cases. We can guide and assist the parties, but we can't really make the decision for them as to whether it's best to proceed now or better to wait. I mean, there are obviously practical problems, as Rhys has already identified. Firstly, the uncertainty over asset valuation. But that needn't necessarily be a barrier to settlement in every case, because there are still going to be some cases where it's possible to share that risk in terms of value by way of some sort of sharing that it means that the value is shared depending on what it amounts to at the point when it's realised. And of course, there'll be some asset values that haven't changed. So the benefits that are paid under a final salary pension scheme or a public sector pension scheme are likely to be the same following the crisis as they are prior to the crisis. And the second set of problems, of course, is the practicality of getting hearings listed, as Rhys again has identified. As we speak, and it's only the third week of the lockdown now, the CFC, along with other courts, are basically not doing final hearings anyway. So to some extent, the issues are being taken out of parties' hands. But even in those cases, there's obviously still the prospect of doing remote hearings. Private FDR is certainly very amenable to remote video hearings. And arbitration, of course, can still be a solution for a final hearing. So even that needn't be a reason why proceedings have to stop at this stage and can't be brought through. So I think the important thing for clients is to understand what the options that they have are, and to understand a little bit about the pros and cons of settling, because none of us know what the future holds. Some people may well think that after a 2 or 3 month period after the shutdown, things will bounce back. There may even be a boom as it bounces back. On the other hand, there are those who say the damage to the economy is such that we're going to be facing a recession that may take months, if not years, to work its way through. None of us have got a crystal ball. None of us know the answer to any of those things. So all we can do is point out to clients that although there's a prospect things may get better, there's also the prospect things may get worse, and they may be better off settling now rather than waiting. And of course, there's other factors. Some people simply can't carry on living together in the same home, so they need to get on and sort out their issues. And there are certain other aspects, such as, for example, only as of yesterday, being the first working day of the new tax year, the rules on CGT have changed, haven't they, in various respects, but most notably in relation to the period by which PPR, Principal Private Residence Relief, is applicable. We know it used to be 3 years, it was reduced to 18 months, and now it's only 9 months. So people who have already been separated for a while are now going to find that the CGT clock is ticking. And that means there is a cost to delay, which needs to be factored in. So I think it's a case of look at your case and decide what's the right thing to do in the particular circumstances. None of us have got a crystal ball. We're all going to have to just lay out the options, and parties are going to have to make their own decisions as to what is the right way forward. But of course, there are going to be those cases where sometimes one party feels that they want to carry on and the other one wants to wait. So what do you think the courts are going to do in those circumstances?
Well, I think it's just going to have to be decided on a case-by-case basis, hasn't it? It seems to me that one of the primary factors to proceed with a case is if the court can reasonably share the risk going forward, because we are now in such uncertainty that, of course, we are now in this sort of risk is clearly going to be something that we need to think about in terms of the Wells and Wells principle, to ensure that there is an equal distribution of it, or at least a fair distribution, if not an equal distribution of it. So it seems to me that, yes, if you can proceed on the basis of dividing assets in a fairly equitable way, whatever they turn out to be worth, it's probably better to proceed if you can. But of course, there are, as you say, so many other factors to take into account. So I think it just has to be case by case, and the judge evaluating the merits and the pros and the cons for each party to reach, of course, usual considerations applying. First consideration, no doubt, being the welfare of the children. So it does seem that there are going to be some very difficult decisions for judges to make now and balancing those risks. Rhys, is there anything else that you've come across that you think would be something people have to take into account when looking at each individual case?
Well, just picking up on your Wells and Wells point, Niki, I wonder whether we'll, for the time being, when settling cases, be less drawn to the clean break, both in capital terms and in income terms. So in capital terms, if you've got a company and the husband needs to buy the wife out, the way to try and spread some of the risk there is to think about the lump sum by instalments, not a series of lump sums, but the lump sum by instalments, which would potentially be amenable to variation down the line if the business doesn't get back on its feet. And then in income terms, there'll be a very interesting question about how one capitalises. You'll recall going back to the 2008-2009 crisis, that Duxbury was tweaked in year one only, and I don't think it's ever been untweaked, but we'll have to wait and see whether or not there are amendments to the Duxbury tables going forwards, and some thought will have to be given as to the rates that get used for capitalisation and whether or not capitalisation is appropriate at all given the current circumstances. And I think there'll be many people out there who want to keep things as open as possible to share the risk, although of course there'll be some husbands out there, it usually will be the husband, who would see this as an ideal moment to try and capitalise on a low basis. As you said a moment ago, it all depends on the particular facts of the case.
Andrzej, do you think there's anything in looking at Wells and Wells a little bit more, perhaps a bit more deeply these days, to see how it's possible in each individual case to share risk? Is there any way you can foresee courts being able to adapt the principles in terms of corporate risk into other aspects of finances?
Yeah, well, I agree. Yeah, it's not just Wells and Wells has always been used in the business context particularly, but we've rather, I think, got used in the last decade or so, particularly maybe even the last 20, 30 years, to really sort of chase the holy grail, which is to give parties finality, to give people certainty, so they only have to come to court once to resolve their issues and then just get on with their lives. And that may become more difficult whilst we're working through the current crisis. So the court's got the tools there to build in flexibility. One only has to look at Section 31 of the Matrimonial Causes Act. There's a raft of orders that are variable. The most obvious are periodical payments, but orders for sale likewise can be varied. So the court can make an order now for a point of sale at some stage in the future. The parties can always bring the matter back to the court to either extend that period of time or indeed to bring the sale forward if market conditions make it suitable to do so. So that's one option people may be looking at. Lump sums by installments, not very often used because people again want the finality and the certainty of a fixed lump sum. But again, maybe we're going to see that coming back, and perhaps even that rare jurisdiction that exists but is very rarely used to vary not just the timing of instalment payments, but even looking at the quantum of them in circumstances where a business has been valued and there are payments to be made out, but then ultimately circumstances change around that. So these are exceptional times. We've seen that through what governments are doing. They're taking steps, paying people's salaries, for example, in private companies, which even 3 or 4 months ago would have been considered utterly unthinkable. Given that governments are taking steps like that, likewise, we as lawyers and judges are possibly going to have to look at the powers that are available and start using them in ways that up until now we thought really isn't the way that we expect them to be used.
Yes, I think certainly I agree completely. I think it's going to be a time of somewhat some great compromise to be made, and also people to accept perhaps that variability may well be the outcome of the case. In other words, that each element of their settlement may be subject to variation if the market rapidly changes, if the housing market drops, or if the value of the business in fact turns out to have been based upon a very different economic climate. So I think you're right. I agree with both of you. I think this is going to be a time where we can't really offer people the certainty and the security of finality that we have always, as you say, tried to provide them with in the past. And it may well be we all have to accept, if we do proceed with the settlement at this stage or proceed with the final hearing at this stage, it's going to be on the basis that parties have to look at the future as possibly being something that they could be revisited.